Co-conspirator, judicial employees fortify Western Australia as a police state. Crimes against the Commonwealth in the Supreme Court of Western Australia. On Thursday the 10th of October 2024, a crime was witnessed in Courtroom 6 at the Supreme Court of Western Australia. The crime was sedition. Police and judiciary collusion. I appealed a decision in the pretended jurisdiction of the Magistrates Court of Western Australia, where Elizabeth Woods, who is doing business as a Deputy Chief Magistrate in the Perth Magistrates Court, determined that public officers doing business as corporate police officers are not accountable for their actions. Police officers do not have to comply with the statutes that they enforce and administer. It was proven that the officers in question did not have a delegation of authority pursuant to Section 8 of the Road Traffic Administration Act, which is an act to provide the administration and enforcement of the Road Traffic Act 1974, the Road Traffic Authorisation to Drive Act of 2008, the Road Traffic Vehicles Act, and for other matters relating to road traffic. Now, on the 16th of September, I submitted an FOI, and a letter was sent back from Shannon Ferguson in response to my FOI request regarding the delegation of function signed and in writing by the CEO of the Department of Transport pursuant to Section 8 of the Road Traffic Administration Act for the following officers: Cole Blanche, Owen Fiander, Jeff Osborne, Tegan Jenna Nelson, Susan Henderson, Carl Webb, Trent Banner, Paul Inkster, Stuart McRae, Anthony Nuttall, and Stephen Young. In regards to your request, as was stated, for the delegation of functions signed and in writing by the CEO of the Department of Transport, I have been advised by the Commissioner's Office that they do not hold these documents, and you may wish to seek this information from the Department of Transport directly. The Western Australian Police FOI also confirmed that the Department of Transport has no record of a delegation of authority pursuant to the Road Traffic Administration Act of 2008, Section 8. And this is the FOI my response FOI to my FOI request. It states that the following officers do not have a delegation of function in writing. You can find this information on my blog on dawnkelly.com.au. This interesting picture here is when Stuart McRae unlawfully stole my car without a delegation of function under the pretense of enforcing Department of Transport policies that he does not have a delegation of authority to enforce. Non-compliance of statutes invalidates the statutes. Forest and Forest Proprietary Limited versus Wilson, 2017, High Court of Australia, Section 61. I've included this citation in my blog if you would like to have a look at it later. I wanted to also share my Supreme Court oral submission given on the 10th of October, which the judge completely disregarded and had a premeditated judgment and did not consider this submission. It is my understanding the Magistrates Court practices a pretended jurisdiction in oppression and denial of my political rights to justice of the Crown within the Commonwealth. Justice, which by right, established in 1900, is current law. The intention of the Acts of 1973 in denying the Commonwealth and Crown jurisdiction by pretence of another under the Crown of Australia is intended to commit a criminal act against the Commonwealth and Crown, insomuch as exercising this pretended jurisdiction is a crime against the Commonwealth and Crown, whereby the rights of the people are violated and denied. How may this be otherwise? Am I not due a reference upon request? It is my understanding that this court affords the protection of justice under the Crown at Section 16 and Section 23 of the Supreme Court Act. Authority to apply justice in Western Australia begins with the Commonwealth Constitution 1900 UK, which provides the authority of the Crown, covering clauses 2 and 5 of the Act. The next authority is letters patent for Western Australia, issued by the Crown of the United Kingdom at Section 2 of the Western Australian Constitution, requires the same Crown for the Queen in Parliament and the Governor's Office to provide royal assent. Criminal Code 1913 WA, Section 44 states that contempt of the Constitution or sovereign is a class of crime called sedition. Is that not the case? Now, a softly spoken Natalie Whitby, doing business as a judge of the Supreme Court, was made aware that a crime was being committed and that she is now a party to. She did look very, very uncomfortable listening to my words on the day. Conclusion. Natalie Whitby's premeditated and predetermined decision evidenced a blatant miscarriage of justice, oral submissions not considered to maintaining a unified approach of pretended authority. Now, full transcripts to come. Now, I'd like to thank you for listening, and please feel free to go to my website for more educational material to empower ourselves, as knowledge is power. Thank you very much.